Welcome to the program, The Ethics of Errors. My name is Tracy Kepler, and I'll be with you for the next hour speaking to this topic. It's not easy being a lawyer. Attorneys face rigid deadlines, packed calendars, and long hours. Clients are often stubborn and unforgiving, demanding 110% of your attention and expecting 5-star work at 2-star prices. As attorneys are only human, even the most skilled and seasoned will inevitably, to some degree, make a mistake. The mistake may be sufficiently serious, such that it may result in a malpractice claim. However, the attorney's management of the mistake is often more important than the mistake itself. The failure to appropriately address an error can exacerbate the simple malpractice situation and give rise to a disciplinary grievance or other claims and increased damages. The political axiom, "It is not the act, but the cover-up that causes trouble," applies to attorneys as well. A desire to conceal mistakes is understandable. Lawyers may be embarrassed to admit to their client and colleagues that they have made a mistake. Notwithstanding this inclination, attorneys have ethical and professional duties to disclose mistakes to their clients. A mistake may damage your case, and it might also threaten your relationship with a client or even your position at a firm. But failing to respond appropriately to a mistake will jeopardize your license and your career. At the end of this program, I hope you'll understand your duties related to error disclosure, what exactly those duties require, and why it's important to take these duties seriously. So starting off, let's talk about why lawyers make errors or mistakes in the first place. We talked about the primary reason, I think. We're human beings. We're bound to make mistakes. Another reason is really ignorance of the ethics rules. We took legal ethics or professional responsibility in law school, but for whatever reason, our retention of those rules, policies, procedures hasn't carried with us, and we're not quite sure about what it means to be diligent or competent or communicate with our clients. In addition, attorneys are busy, sometimes unorganized. We procrastinate. We may not get things to as fast as we would like, and some things that we may not like may end up in the bottom of the inbox, only to be forgotten about and to have missed a statute of limitations. Other reasons that we make mistakes: personal financial pressure, the pressure to get and then retain clients. Also, the act itself, the pressure to win at all cost, having this zero-sum game. In addition, there are often well-being issues at play, certain substance use disorders or mental health issues from which we may be suffering, or maybe even a cognitive impairment. For the more seasoned practitioner, dementia, Alzheimer's, something around being impaired as a result of mental function. And then lastly, I think there's a continuum of good and evil. There are attorneys where there are just isolated instances of neglect, that simple mistake, to the middle of the road where attorneys may see, wow, there's this whole pile of money sitting in my client trust fund account, and I just need to borrow some for a short period of time, and I'm going to pay it back as soon as that next settlement comes in. No client will be harmed, no mistake will happen, it's all going to be okay. To the other end of the spectrum, where there are attorneys who set out to steal from widows and orphans, and on those, rather not a mistake or an error, but intentional. The foundation of the duty to disclose. An attorney who commits a material error must inform the client of that error. This duty is as old as the profession itself, and traces its origins to an attorney's role as a fiduciary. The Eighth Circuit Court of Appeals has characterized the common law duty to disclose errors as a corollary of the fiduciary obligations of undivided loyalty and confidentiality an attorney owes their clients, reasoning that the client must be aware of acts or events under their control and any circumstances that may limit the attorney's ability to ethically continue the representation.